Hello everyone. The case that was assigned to me is the case of Roxas and Company Incorporated versus DAMBA-NFSW and Department of Agrarian Reform, GR number 149548, December 4, 2009. Here are the facts of the case. The main subject of 7 consolidated petitions filed by Roxas and Company Incorporated is their appeal for the conversion from agricultural to non-agricultural use of its 3 haciendas located in Nasugbu, Batangas. Before the effectivity of Comprehensive Agrarian Reform Law of 1988, petitioner filed with the Department of Agrarian Reform a voluntary offer to sell of Hacienda Kailaway pursuant to the provisions of Executive Order Number 229. Haciendas Palico and Banilad were later placed under compulsory acquisition by DAR. However, in 1992, petitioner sent a letter to DAR withdrawing its voluntary offer to sell of Hacienda Kailaway for reason of its application for conversion from agricultural to other uses. This is in relation to the alleged reclassification of Hacienda Kailaway from agricultural to non-agricultural as authorized by the Sangguniang Bayan of Nasugbu. Meanwhile, 2 petitions nub on the interpretation of Presidential Proclamation No. 1520 declaring certain areas in Cavite and Nasugbu to have potential tourism value after being developed into resort complexes for the foreign and domestic market. Thus, the Philippine Tourism Authority or PTA has to conduct studies and to segregate specific geographic areas for developing their tourism potential. Roxas and Company Incorporated filed its application for conversion of its 3 haciendas on the assumption that the issuance of Proclamation Number 1520 reclassified their haciendas to non-agricultural uses. The Court of Appeals remanded to the Department of Agrarian Reform the observance of proper acquisition proceedings. During the pendency of its application for conversion, petitioner filed with DAR an exemption from the coverage of Comprehensive Agrarian Reform Program or CARP on the basis that the Presidential Proclamation No. 1520 and DAR Administrative Order No. 6 Series of 1993 stating that all lands already classified as commercial, industrial, or residential before the effectivity of CARP no longer need conversion clearance from the Department of Agrarian Reform. At this juncture, the Sangguniang Bayan of Nasugbu enacted Municipal Zoning Ordinance No. 4 stating that only 2 barangays were considered as industrial zone, excluding petitioners' 1 hacienda. It was later approved by the Human Settlements Regulation Commission, while the Sangguniang filed a petition for intervention but was later denied. We have 3 issues to be solved in this case. First, whether the Presidential Proclamation No. 1520 reclassified all lands in Maragondon, Ternate in Cavite, and Nasugbu Tourism Zone to non-agricultural use, which exempts Roxas and Company's 3 haciendas in Nasugbu from CARP coverage. Second issue, whether Nasugbu Municipal Zoning Ordinance No. 4 exempted certain areas or certain lots in Hacienda Palico from CARP coverage. Third issue, whether the partial and complete cancellations by DAR of Cloa number 6654 subject of 1 of the petitions is valid. Based on the decision of the Supreme Court on the first issue, the court said that the Presidential Proclamation 1520 did not automatically convert the agricultural lands in the 3 municipalities, including Nasugbu, to non-agricultural lands. So the court made it clear that the power to determine whether haciendas Palico, Banilad, and Kailaway are non-agricultural, therefore exempt from the coverage of CARL, lies with the Department of Agrarian Reform, not with the court. So Presidential Proclamation 1520 merely recognized the potential tourism value of certain areas within the general area declared as tourism zones. Interestingly, the Presidential Decree Number 2, which declared Philippines as land reform area, did not intend to reclassify all lands in the entire country to agricultural lands. It bears emphasis that a mere reclassification of an agricultural land does not automatically allow a landowner to change its use, since there is still the process of conversion before one is permitted to use it for other purposes. On the second issue, the court ruled that the application for CARP exemption by the petitioner in Hacienda Palico cannot be granted in view of discrepancies in the location and identity of subject parcels of land. The DAR Secretary denied the application for exemption of petitioner. However, during review of the titles, it shows that the origin of some titles are not the same with the other title. The discrepancies were attributed by petitioner to typographical errors which were acknowledged and initiated by the Register of Deeds. However, upon verification, the discrepancies cannot be ascertained. Moreover, petitioner failed to submit a title which it claims over 3 lots. So, a scrutiny of said ordinance shows that the only barangays Talangan and Lumbangan of Nasugbu were classified as industrial zones and Barangay Kugunan was not included. So, in granting the application, the DAR Secretary examined the evidence submitted by petitioner, which consisted mainly of certifications from various local and national government agencies. The court finds that the DAR Secretary indeed committed grave abuse of discretion when he ignored the glaring inconsistencies in the certifications submitted by the petitioner. In this regard, the court finds observation of DAMBA-NFSW that petitioner should have submitted the comprehensive land use plan and pointed therein that the exact locations of the properties to prove that indeed they are within the area of coverage of Nasugbu Municipal Zoning Ordinance Number 4. On the third issue, the Supreme Court decided that the petition's application for CARP exemption for 9 parcels of land in Hacienda Palico should be granted. So an application for CARP exemption pursuant to DOJ Opinion Number 44, Series of 1990, as implemented by DAR Administrative Order Number 6, Series of 1994, is non-adversarial or non-litigious in nature. Therefore, the applicant is correct in saying that nowhere in the rules is it required the occupants of a land holding should be notified of an initiated pending exemption application. The failure of DAR to comply with the requisites of due process in the acquisition proceedings does not give the court the power to nullify clauses already issued to the farmer beneficiaries. So since the subject land holding has been validly determined to be CARP exempt, therefore, the previous issuance of Cloa of oppositors movants is erroneous. The petitioner, therefore, is mandated based on Republic Act Number 3844 to first satisfy the disturbance compensation of affected farmer beneficiaries in the areas covered by the 9 parcels of lands before the clause covering them be cancelled. So that's the case that was assigned to me. Thank you.